Why don't you go ahead?
Good morning, everyone. I'm David Garvin. I'm a board-certified tax attorney, and I've been practicing in criminal tax defense, white-collar crime for the past 28 years. I'm also a certified public accountant, and I have an LLM in taxation. My practice involves mainly litigation or preparation of cases in anticipation of litigation, with an emphasis on the criminal defense side of the case. With regard to this topic, the Foreign Account Tax Compliant Act, we're viewing this as an extension of the administration's mandate to try to bring the maximum number of taxpayers in compliance with the Internal Revenue Code. And as a result, they have enacted this new Chapter 4 to try to do a better job of getting information than what was previously out there, known in the banking industry as Know Your Customer rules. Now, because of the gap that is necessary in mandating such a huge project, the IRS has brought forth these voluntary compliance programs or voluntary disclosure initiatives, and as we all are aware, the first bank that tried to resist was UBS, and that did not work out so well for UBS, and it resulted in literally thousands of people either leaving UBS or participating in the 2009 initiative with the voluntary disclosure. As Dennis alluded, there are always people who will come in after the deadline, so even though they extended that deadline and they thought that they gave people an incentive to comply by reducing the penalty from 50% to 20% and by reducing the fraud penalties on the income tax aspect. That is that the 20% related to the FBAR penalties, but then you had income tax aspects of the cases also. Well, when that expired, as we know, they came forward with the 2011 initiative, increased the penalties to 25% on the side of the FBAR, and 20% is now the cap for the income tax side of the cases. What we are looking at is people that come through the door and they say, I have a problem. I have reason to believe that my banker at, and then they name a bank, has turned over my records, or I have reason to believe that my records have been requested, and now what do I do? Can I get into the voluntary disclosure program? Is it too late to get involved in the voluntary disclosure program? Or worse, it is a particular client in which you have sent out the initial disclosure form only disclosing the name, social security number, and date of birth to ask for pre-clearance, and that clearance has been rejected. Now what? Those are the types of cases that we're handling in my office, and we see this entire learning experience with the voluntary disclosure program as being simply a precursor of a much, much larger project in the FATCA program that is coming just right around the corner. As we probably all know, the foreign financial institutions, the FFIs, are going to be requested to enter agreements by June 30th of 2013. And in those agreements, they are signing on to be somewhat of police officers in foreign lands. They're going to have to take on the role of going through their existing accounts and determining which ones need to be reported to the IRS. And they're going to have to police payments that are being made to other FFIs. And if those FFIs have not entered an agreement and are trying to circumvent the agreement by going through an FFI that has, then the FFI will be required to withhold 30% of the funds to the FFI that has not entered the agreement. You will also know that there are methods for the foreign financial institution that has entered into the program to opt out of the obligation to withhold from other FFIs. And it becomes pretty complicated and pretty sticky because there are issues as to whether you are going to be abiding by your obligations under your agreement, and your clients in particular, and whether they are aiding and abetting people who are circumventing the rules. And obviously, those all have civil ramifications, but they also have potential criminal ramifications. That is not to mention all of the clients of those foreign financial institutions who have to make the decision whether to stay as account holders or members of the foreign financial institution. We will recall that foreign financial institution, the definition is not limited to the traditional bank. It covers an entire array of legal forms of entities, trusts, and other types of entities. So we have a myriad of issues that are on the horizon, and really the only thing that we have to go on as far as practical experience is our experience with the voluntary disclosure programs and how the banks have been treated when they resisted complying. They have not been treated too well. So with our knowledge as to how both the taxpayers and the financial institutions have been treated under the voluntary disclosure programs, both the 2009 initiative and now the current program of 2011, which will be expiring in September, we can forecast what is likely to be on the horizon. Some people have suggested that we're likely to see a 2012 voluntary compliance disclosure program with a 30% penalty as a one last step before the FATCA is brought into full force and effect. However, as practitioners, everyone here is going to be asked by their clients tons of questions. And I think that the fundamental question is going to be from the taxpayers: what are my obligations, and what happens if I take my account out of the foreign financial institution? And obviously there are some date problems with that too, because the foreign financial institution that has registered has to report accounts that are closed also, and what the amount was the day before the account was closed. So if somebody is going to close their account, they may well be thinking about closing the account before the June 30th, 2013 date comes about. Those are the types of things that we're looking at in my office, and I'm certain the types of things that you'll be presented, if not already, in the near future. And we anticipate, with the vicinity that Miami shares with South America, that the volume of these issues is going to be quite a tidal wave in 2013 and in the latter portion of 2012.
Thank you, David. I can almost envision, like a musical chairs, accounts moving around from bank to bank, trying to sort them out, like a deck of cards, perhaps. And that's just one of the issues. Obviously, people are in companies as well are going to have to be going back, looking at their old returns, and making strategic decisions as to how to handle it.